Today, we will walk through what a child support order is. A child support order determines the amount of money the parent without primary physical custody of the children must pay each month. The parent who pays child support is called the obligor, while the parent who receives the child support is called the obligee. A child support case may be brought by the Office of the Attorney General, Child Support Division, after a parent applies for child support through their office. To be on the hook for child support, the paying person must be the child's parent. When a baby is born to married parents, the law automatically assumes the spouses are the parents of the child. Married couples do not need to take any more steps to prove who is the father, and they can move on to determining how much child support can be received. If the mother is still married and is pregnant by someone different than her spouse, the mother must go through the process of proving who the actual biological father is. This process is called establishing paternity. When a baby is born to unmarried parents, the law does not automatically assume the biological father is the legal parent. Only the legal parent is responsible for child support. Because the law does not assume who the parent is, the person wanting child support must prove who the parent of the child is. There are 3 ways to prove who is the parent of the child. 1. Voluntary paternity establishment. 2. Agreed paternity order. And 3. Court-ordered paternity. The voluntary paternity establishment means both parents agree the man is the child's father, and the parents sign a document called an acknowledgement of paternity. An agreed paternity order is filed with the court. In an agreed paternity order, the parents state and agree who the father of the child is. In a court-ordered paternity order, the court decides who the father of the child is when the parents do not agree on the father's identity. After the parents of the child have been proven, the next step is to determine how much child support is to be paid. Texas uses the percentage of income approach. The percentage of income approach means that the paying parent pays a set percentage of their income. The percentage may depend on the income of the parent who is paying child support, the number of children the parents have together, and if the parent paying child support has children from other relationships. A child support case will likely also establish child custody. For more information on child custody, please watch our Understanding Child Custody video. If you are applying for assistance with establishing child support through the Office of the Attorney General Child Support Division, and you are a survivor of family violence, it is important to let the Attorney General's office know that you would like to have your case flagged for family violence. This may allow you additional protections, such as keeping your address private and not requiring you to mediate the case. If you have a child support order currently and the obligor parent is behind in child support, the Office of Attorney General Child Support Division may also help enforce child support orders. What a family violence protective order is. A protective order is a kind of court order that can help keep an abuser away from a survivor of abuse. A family violence protective order is used against abusers who are intimate partners or family members, including current or former spouses, dating partners, blood relatives, and members of the same household, such as roommates. Once a protective order has been issued, the abuser is not allowed to hurt, threaten, or harass the survivor directly or through another person. The abuser must stay away from the survivor's family, home, job, and school, and the abuser is not allowed to possess a gun. If the person that the protective order has been issued against, the abuser, violates the protective order, the survivor has two ways of enforcing the protective order. Enforcement means requiring the abuser to follow the rules and requirements of the protective order. You can enforce the protective order either through civil or criminal punishments. The civil punishment for violating a protective order is civil contempt and can include consequences such as a fine or even jail time. The criminal punishment for violating a protective order is a possible misdemeanor criminal charge. Typically, a family violence protective order lasts for 2 years, but it can be extended up to a lifetime depending on the extent of the physical violence. A family violence protective order can be filed by the survivor, an attorney, CPS, or a parent or guardian if children are involved. If you are interested in learning if a family violence protective order would be a solution for you, call 800-374-HOPE. Of what a divorce lawsuit is. A divorce case is a case that legally ends a marriage. A divorce case begins when one spouse files an original petition for divorce with the court. That spouse is called the petitioner. The spouse who is served with the original petition for divorce is called the respondent. A divorce case is often described as multiple lawsuits in one. A divorce case will determine the grounds or reasons for the divorce, and the case will divide any community property and debt from the marriage. If there are children of the marriage, custody and child support can be established or modified through a divorce case. Additionally, the petitioner may make special requests to the court to ask the judge to order the respondent to be stopped from doing something. For example, in marriages involving domestic violence, one spouse may ask the court to set restrictions on the other spouse's ability to contact them. This is called a permanent injunction. Another common request addressed in a divorce case is a name change. It is important to know that Texas does not have legal separation. If you are married and want to permanently end your marriage, you need to file for divorce. If you believe you may have a common law marriage and need to legally end your relationship, please contact an attorney to best evaluate your specific case. We're going to walk through what it means to terminate parental rights. A termination of parental rights case ends the parent-child relationship between a child and parent. Terminating parental rights ends all legal rights a parent is entitled to as the parent. These rights include having physical possession of the child, choosing where the child lives, where the child goes to school, what medical care the child receives, and receiving information about the child. If a parent's rights are terminated, the parent is no longer entitled to participate in decisions related to the child. Parental rights can only be terminated or ended by a court order. While a parent can sign a waiver to voluntarily end their parental rights, this does not terminate the relationship until a judge signs the order of termination. Terminating parental rights is a high bar, and courts do not make that decision easily or lightly. Parental rights will be terminated if keeping a parent-child relationship between the parent and child is against the best interest of the child. The standard to prove that the parent-child relationship is not in the best interest of the child is clear and convincing evidence. If a parent does not voluntarily waive their parental rights, a judge can only order termination in a limited number of circumstances. Some reasons a judge may terminate parental rights include the parent abandoned or did not support the child and expressed no intent to return, the parent endangered the child, the parent engaged in certain criminal conduct, the parent is otherwise unfit, the parent was convicted of abuse or neglect of another child, the parent kept the child out of school or away from home, or the parent is imprisoned and cannot care for the child for 2 or more years. Some of the effects of terminating parental rights includes ending child support obligations, ending the child's right to inherit from the parent whose rights were terminated, and making the child eligible for adoption. Terminating parental rights has big consequences for the parents and the child. If maintaining a legal parent-child relationship is not in the best interest of the child, terminating parental rights may be an option to pursue.